All rise. The Minnesota Workers' Compensation Court of Appeals recommences. The Honorable Thomas Christensen presiding.
Good morning. Please be seated. Welcome. This is oral argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is October 30th, 2023. The argument today is being live streamed and recorded, and the device that you see on the podium in front is picking up both visual and audio. But to that end, you need to speak up loudly and clearly for it to be picked up. And I'm trying to do the same thing because apparently it has difficulty picking us up. Today's second oral argument is WC 23-6516, Mark Melius, the ACME Tuckpointing and Restoration. We have a three-judge panel today. Right is Chief Judge Millen. To my left is Judge Quinn. We understand, Ms. Hammers, that you are representing the respondent today, and this is your first oral argument, so we welcome you. Mr. Batchelor has been here before, but it's always nice to see you. Should remind everyone, counsel, you have 15 minutes for your argument this morning. The yellow light will come on in 2 minutes, and it's up to each attorney to keep track of your time. Please be aware that in the past we've had given you an opportunity to make your argument before we ask questions. That's kind of what we're doing anymore, so be prepared for questions at any time. And please, when you come to the podium, state your name and the party that so we can keep streaming. And with that, Mr. Batchelor, you're the petitioner.
Thank you, Your Honor. May it please the court, my name is James Batchelor. I'm here on behalf of the employee petitioner in this matter, Mark Melius. We're here today in an effort to vacate a stipulation for settlement that was submitted to the Union Construction Workers' Compensation Program back in November 2015 and resulted in an award on stipulation issued on December 1st of 2015. Straight away, I'd like to address one argument that respondent made in their brief as it related to the timing of our petition that brought us here today. First, the law says nothing about the timing of a petition having an impact on the substance or whether or not a stipulation for settlement should be vacated. Secondly, there was an assertion that the petition was motivated or triggered by, in some way, some denial of some other workers' compensation benefit. And I can assure the court that that is the furthest thing from the truth. We didn't file this petition. A pleading that we take
very seriously. I'm going to interrupt you a minute. At the time, my understanding is a rehab or a vehicle adjustment was being sought through that process. Why would that even matter?
It doesn't,
okay.
But that's my point.
So is there an inference in the respondent's argument that makes you believe that would be a factor for us to even consider?
The fact that they brought it up, to me, it was a cheap shot. So yes, and that's why I wanted to address it first, because it doesn't have anything to do with the law and it doesn't have anything to do with our petition or what motivated our petition. And our petition was driven by the circumstances. Two of the critical things that we felt like we needed to have in order to submit our petition was medical support for, one, the change in diagnosis, which, as the court knows, is one of the factors under the fondness case. And then secondly, that causal connection between that change in diagnosis and the original work injury. So it wasn't until we had medical support for that, which came in the form of Dr. Larkin's report in the middle.
I don't want you to lose your time and digress too far off the beaten path of what you need to talk about today. I didn't understand why that was relevant. I kind of went through it, saw it, and moved on. So I was just trying to get your take on it. before I
Okay,
had it-
and that's,
before
fine.
it-
I appreciate that, Your Honor. Your take was identical to the one I had.
Okay,
I also felt like I couldn't leave it unaddressed
absolutely.
because because of the way I felt about it generally. So then that's one of the reasons why we didn't file this petition. So what are the reasons why we did? And the two major bases, as were outlined in my brief that we submitted, or the memorandum in support of our petition, is one, there was in fact a substantial change in medical condition, and two, that the award of the settlement and the funds that were paid to Mr. Melius secondary to this work injury were vastly disproportionate to the duration of the disability and the extent of the benefits that would otherwise have been available. So, as the court knows, change in condition, where do we all go? We go to the Podnas case to identify what are the factors for this court to address to see whether or not this is in fact a stipulation for settlement that should be vacated. And the first one is that change in diagnosis. In this case, after Mark's surgery in 2012, he was diagnosed with static post-fusion surgery. After the surgery he had in 2022, he was diagnosed with quadriparesis and quadriplegia. So a significant deterioration and a change in diagnosis. So that's one factor to address. The significance, I think, of not only the medical diagnosis, but also just the change in Mark's ability to function. Certainly he had limitations secondary to fusion surgery. Certainly he had some difficulty with day-to-day activities, but not to the extent that he's suffered since the 2022 surgery, where now he is required to have daily care performed by somebody else. He's wheelchair bound. He requires a hospital bed in his home. He needs an accessible vehicle to get from place A to place B. So as a functional matter, the diagnosis is one part of it. The functional impact is dramatic. Second,
Counsel, I just had a question. Looking back at the stipulation for settlement, there were references to some medical reports and from the employer insured. But in reviewing stipulation for settlement and the attachments, I didn't see anything at all when the stipulation was entered into medically showing that Mr. Melius was unable to work and was permanently totally disabled. Is that a fair understanding on my part?
They didn't get that far down the road, Your Honor. What happened was, and again, I took this case over in 2022, so I had 11 years of medical records to kind of catch up on. But what I did know was that Mark had been released to return to work. He had reflected to the doctor in the office notes that, he had had his life back a little bit, was one of the things that he was quoted as saying in the medical records. And he was working at the time they were negotiating these settlement terms. So the case hadn't gotten all the way to a hearing, so there wasn't that, here's an adverse opinion saying he's not permanently and totally disabled versus here's one that's saying he is. But certainly there was a discussion, and counsel will address during the course of this, there were some allegations that he was permanently and totally disabled at that time. I don't think we can run from that. He was at the time working part-time. And so I think the analysis, I wasn't there, was, is this a perm total case or is this a temp partial analysis when they were doing the settlement negotiations?
That's present with Mark Larkin's, Dr. Mark Larkin's dispute resolution report. He's made a finding now that Mr. Melius was permanently totally disabled from the date of the injury, and that's a new report and a new opinion.
Correct. That's as of May 16th of 2023, Your Honor. That actually brings up the next of the fondness factors, Your Honor, is as it relates to the employee's ability to work.
I'm going to have to interrupt you again because my understanding is that there's 11 months between the surgery and the settlement. Is MMI in here in those 11 months? And he goes in January of 2015 for fusion at C4 to 7, right? In 2015. When was the surgery?
The surgery that Mark had that led to the settlement discussions was in 2012. And
I
then
have
the
to
negotiators,
check the anterior certificate. Well, there's 2 dates of injury, July 21st.
July 21st and July 28th, both of 2011. Mark undergoes a fusion surgery in 2012, and then was back working at roughly 4 hours a day, 5 days a week for 2 years between 2013
So I have the
and
date wrong.
2015. And so, and then they settled the case in November of 2015. The award was issued December 1st of 2015. And then Mark had intermittent treatment between 2015 and 2022. Things really deteriorated in 2021, and that's what led to the surgery that was done in 2022. And that's the one from which that gave rise to why we're here today. And I think that
Was he
surgery.
at MMI at the time of settlement? I haven't, the reports I have reviewed, but better position to tell me, yes, Judge. He was at MMI at the time of settlement. Here's the report that verifies it.
Off the top of my head, I cannot cite you to that report, but again, the surgery was done in 2012 and he was back working in 2013. So my suspicion is, yes, he was in fact at maximum medical improvement and had been released with restrictions at that time.
Okay.
That does address, again, the employee's ability to work. He was working, the job did go away, and I'm sure council will make an issue of that. The company Mark worked for was purchased by somebody else who could not accommodate the restrictions. We're now running from the fact that he was restricted in his activities related to work. But the plan was to work with the QRC to engage job placement, to find alternative employment as they negotiated the settlement. And again, I think from what I've seen in the file, some of the battle was, is this a temp partial case? Is this a perm total case? Which, as you all know, that can happen as we litigate these work comp cases and engage in settlement. But ultimately, they reached a settlement, so the assertions were not made directly in front of the judge. There was not findings in order that arose out of that because the case ended up being settled.
And having said that, then we look at the contentions of the parties, correct?
Correct. That's correct, Your Honor. You do have to take those into consideration, and I'm hopeful that when we do these stipulations for settlement, they're not all just boilerplate and that those things would be accurate. There was some assertions that Mark might be in fact permanently and totally disabled. Obviously, that assertion was rejected by the employer and insurer at the time related to, Mark's ability to work at that time. But what's clear now at this point, which again, because what we're dealing with is should the stipulation be vacated, we're dealing with how dramatic is the change in the condition. And our argument as the petitioner in this matter is, look, there was first of all, his ability to work was shown by more than 2 years of employment. And then secondly, he had the ability, he had the functional capacity. Maybe it wasn't going to be 40 hours, 8 hours a day, but he had the ability to work if he needed to. He could self-care, he could function, and was looking forward to that at the time of the settlement. And then now, since this most recent surgery, Mark's in a situation where he's dependent upon others for his daily self-care. And as you point out, Your Honor, the work with Dr. Larkins indicates he's permanently and totally disabled. Unemployment is no longer an option for him. One of the other fondness factors is the increase in the permanent partial disability. Certainly in permanent partial disabilities, post-fusion surgery, multi-level, 15%, 17.5%. Mark's lost the functional use of 3 of his 4 limbs. So the increase in the permanent partial disability as it relates to that would be substantial. We've not had a formal rating issued by any doctor. That's not been addressed, but certainly we would take the position that quadriplegia as a diagnosis would add substantial permanency to the 17.5% that was previously addressed. Medical treatment, future medical care contemplated. Council points out in their brief that medical was left open. Certainly it was, but it's our contention, Your Honor, that the nature of that treatment, which was reasonably anticipated at the time of settlement, steroid injections, physical therapy, maybe even surgery, all of those things were likely contemplated at the time. What wasn't contemplated was a hospital bed, a wheelchair, 4-day-a-week physical therapy, just so Mark can find a way to at least, like, one of the records from physical therapy, it's a victory if Mark can wiggle his toes. That's a victory. That's not the type of medical treatment that was expected or anticipated when this case was settled. And so it's our contention that that factor also weighs in favor of vacating the settlement. Causation, is this related to the injury? There's one uncontroverted medical opinion that connects the two, it connects the original injury to this circumstance. So that factor, we would argue, weighs heavily in favor of Mr. Melius. Then the contemplation of the parties at the time of the settlement, I certainly can't speak to what the employer and insurer were contemplating. But Mark issued an affidavit indicating what he thought. He thought he was going to be able to be independent. He thought there was chances of him returning to work. He thought he was going to be able to self-care, live his life, function independently, and that sort of thing at the time. And those things are no longer true. The final argument I would make as it relates to the fitness factors, it's not a specific mathematical formula. I think sometimes that I wish it were, that you get a certain point value for each one of these vectors, and if you get over the threshold, then you get the thing vacated. But I think frankly that might put us all out of a job if it were that easy. It's not that easy. But I would say when you look at the totality of the evidence in this case, the overwhelming change from where Mark was in 2015 relative to where he is in 2023, we would argue that those fitness factors, when you apply each individual one, does in fact support the idea that this step should be vacated. Finally, the other basis, Your Honors, as it relates to our petition to vacate, and I'm running out of time here, but the other basis is the proportionality of the value or the exposure relative to the settlement. This case was not settled for an insignificant amount of money. Can't run from that. $175,000, especially in 2015, was not an insubstantial amount relative to the over $900,000 in exposure that would be available had Mark been assigned permanent total disability dating back to the original injury, had that continued up through now and through his presumed retirement age, and then add the additional permanency. That is a relatively small proportion. So based on that, we think that also supports petition to vacate, and we would ask that this court issue an order vacating the stipulation. Thank you so much for your attention and time.
Mr. Batchel, I know you're out of time, but I want to ask you some questions. And
Sure.
Ms. Hammer will get additional time if she needs it to. As to your last point, there was also a third-party settlement. Do we take that amount into consideration when we look at the degree and duration of the proportionality of the settlement amount versus, what we're looking at here?
Courts and judges are human. I think certainly it's hard to run from that as a factor. I don't see anything in the case law that says one way or the other. Is Mr. Melius fortunate because there was an additional settlement? Certainly, I think that it's hard to not think of that, but I don't know that there's anywhere in the law, certainly not the law that addresses workers' compensation claims, that says that the court can, and so we would encourage the court not to. I don't have a specific site to give you, Your Honor, that says one way or the other.
And then I get what you said about certain things not necessarily being relevant, like the timing, the initial part of your argument, but you're certainly allowed to share this with us. What is the status of that arbitration hearing regarding the accessible vehicle and the eyeglasses?
We are working on, as of last week, we've had a little trouble scheduling it. The arbitrator said, okay, it's go time. We're going to try to get this done within 30 days. And we've just been back and forth between the arbitrator's office, counsel's office, and trying to get that on the books. But the anticipated date is sometime before Thanksgiving.
Okay, so there was a date in September that didn't happen.
That didn't happen because of the nature of the claims, and
it just didn't happen.
But it's not.
And then I've got two other things I want to ask you about. the most recent surgery, I assume no, but I'll just ask, is there a malpractice claim in there, another third party?
No.
And then the last thing I want to ask you about is the Social Security. We have the affidavit. Mr. Melius said, I don't have enough quarters. That's the only evidence that we have. Did he have any legal assistance in attempting to apply for Social Security disability?
Not after there was a note from the Social Security Administration telling him that there was insufficient orders to qualify so that there would not be a Social Security offset.
Okay. Is it in the form of a question or just say it? I'm going to ask you a hypothetical question. And this may or may not be relevant to the petition to vacate, but it certainly is relevant to your client and may be relevant to Ms. Hammer's client, depending upon the outcome of this bar decision. After your client settled the case in 2015, as I understand it, he didn't work anymore after that, or if he did, he worked very minimally, correct?
That is correct.
Okay. Are you familiar with how Social Security counts quarters of coverage?
I mean,
You personally aware of how they do that? How you earn a quarter of coverage from working and all
I think
that?
I have a lot of presumptions about how that would be done.
Okay. Well, when somebody goes to the Social Security Administration, one of the things that the clerk might do is say, well, let's look and see if you have coverage. And it sounds like the clerk told your client, you don't have coverage, so you're wasting all of our time.
That's correct.
However, there is nothing preventing an employee, I shouldn't say employee, a claimant from going to the Social Security Administration and saying, I would like to apply for Social Security disability, and I want to allege that my disability date is way back to 2011. Here's a report from a doctor that was hired by a union arbitration program to say that I've been disabled since 2011. And then the Social Security will look at whether your client has quarters of coverage. Then,
That's
Not
dated
now.
2011 as opposed to that,
Yeah.
the date of the
yeah,
application.
and my guess is your client had quarters of coverage that expired probably in around 2020. So, my question then, since I have to ask it in the form of a question, is, has your client applied for disability alleging onset retroactive in time?
Don't know what date he alleged
So
specifically.
he may not have even applied, it sounds like.
Well, there was an application. What I found in the file, again, having taken it over, was that there was a specific memo from Social Security saying you don't have enough quarters to qualify. So I don't know what date was asserted as part of the application. I just know the way the administration responded.
Okay. Well, as somebody who used to have a whole lot of experience doing that kind of stuff, I know how the clerks get, and have to be assertive and tell them that. So it might be of some benefit to your client, and again, depending upon the outcome of this decision, an offset to Ms. Hammer's client if he were to try again, maybe with the assistance of Social Security Council. So, anyway,
Thank you, Your Honor, for that bit of insight. Thank you all for your attention tonight.
thank you.
Ms. Hammers, you have 15 minutes and another 6 minutes and 30 seconds, so 21 minutes and 30 seconds.
Thank you, Your Honors. May it please the court, my name is Katie Hammers, and I am here on behalf of the respondents, ACME, Tuckpointing, and Restoration, and the Builders Group. Now, sympathy aside, it's the position of the respondents that in this case, the petitioner has not met his burden of proof to establish that his unfortunate surgical outcome in 2022 meets the statutory requirements to justify vacating the stipulation for settlement. Now, before I go directly into the FODMAS factors, I would like to point out a few things. First, when I was reviewing the records again that were attached to petitioner's brief under Exhibit F, it's the Twin Cities Spine Center exhibits. And those do show that the surgery was performed in January of 2015. I think it's page 28 is where they go through the risks of the procedure and inform him of those risks. And I believe shortly after that, he has his pre-op, and I was having trouble locating right now the actual surgical note, but as of page 33, I think he was 5 weeks post-op, and that was in 2015. So it is my understanding that there was no maximum medical improvement as of the time that the prior stipulation for settlement was entered into. I would like to also address the assertion that $175,000 was inadequate compensation, given that there was exposure of $900,000. This does not take into consideration the prior indemnity payments that were issued up until the date of the award on stipulation. There was over $170,000 in those benefits paid at that time. So
that puts us at 303 and a half.
yes. And the exposure through that time would have been around 500,000, so it's closer to a 70% as of that time. So the settlement does appear to be fair in my perspective. So now jumping into the FODMAS factors, there are a couple that I would like to point out as I believe not clearly met in this case. The first is that the petitioner has not established a change in his ability to work. Now, there was mention of Dr. Larkin's May 16th, 2023 report. It's my position that his finding that the petitioner was permanently and totally disabled dating back to 2011 actually shows that there wasn't a change in that workability. He had some sporadic employment that was at most 4 hours a day, and in the deposition testimony that's provided as an exhibit to petitioner's brief, he does discuss that most times he was not able to even work 4 hours a day. He also provides in the affidavit that he acknowledged that in November of 2015, so shortly before the stipulation for settlement, the employer that he was working at the time, 4 hours per day, had been bought out by a new business that was going to not be able to accommodate his restrictions at that time.
Ms. Hammers, I'm going to interrupt you a moment because I'm struggling with one of the factors, and that is the material change in his medical condition that was not anticipated. Do we anticipate the outcome of his second surgery to be the exact diagnosis and current condition, Mr. Melius, today? Is that something that we anticipate, or is that just part of a signature and informed consent when you go in for the surgery? And is there a distinction of merit here?
In this case, I believe it is something that you anticipate. It's something that you might not hope for, but you are warned about it. In these neck procedures, especially involving multi-level fusions and removal of those fusion surgeries, in the records, there's a warning of instrumentation failure as well. So it is unfortunate, and I believe that.
I want to go back because there's a standard here. An informed consent, does that really rise to the level of an anticipatory event, such as the one which the employee is presently under? And if so, why would anybody, if it was rising to a level and you would assume that risk, or is it just something mentioned? You know, you could, anytime you go under, you can basically have a catastrophic event that ends your life. But is that really the same as anticipation?
I believe in this case, the fact that there's no malpractice suit against that unfortunate outcome kind of goes towards the presumption that it could have been anticipated. If there's not a legal basis or a malpractice basis to dispute that the surgery was negligent. If it was informed consent, if informed consent did not matter, I believe in that case, there would probably be a malpractice.
See, I don't want to say it doesn't matter. I'm asking you, does it rise to a level of the statutory claim that you contend today, which is there some material change in his medical condition that was not anticipated? Because that's where I'm kind of struggling.
And I'm going to add to that, because the statute says more than anticipated, it's basically reasonably anticipated. I mean, if one reasonably anticipates a catastrophic outcome from any surgery, I don't know if one ever has a surgery versus knowing it's a possibility.
That's a tough question.
I know. I
I mean, that's what we're struggling with here. I understand
Yeah.
the analysis of the 5 inspectors, and we've all been through this case, not regarding the actual facts of this case. But is that something that really is reasonably anticipated as Judge Quinn has?
And it's my position, again, that it is reasonably anticipated. Again, this isn't like undergoing a foot surgery and then all of a sudden having some sort of catastrophic outcome that impacts all of your limbs unknowingly. In this case, it's a neck surgery, and those involve nerves and are highly sensitive. So there's a level of risk that patients are aware of more so when undergoing these types of procedures. And it's documented too in the levels of permanency that gets paid out for these types of procedures, the time off work, and the in-depth recovery process that a patient undergoes. I believe it is more, and there's more understanding that those risks are inherent in these types of procedures.
And that's a really good point, but if I move to the level of the specific facts of this case, the fact that the employee had such a good outcome first time around, would that even reduce in the facts of this case that he would reasonably anticipate the condition and diagnosis that he received when the surgery is pretty much the same, but you're just moving an upper level and you're taking out instrumentation? It's not to diminish the surgery itself, but it's quite similar to what he originally had, and he had an incredible recovery.
Your Honor, I believe in hindsight that it may appear to be an incredible recovery, but the records that were provided and attached to our exhibit include the United Pain Clinic records with Dr. Hess, where he was using narcotic pain medication at high levels. There had often been disputes about the pain medications. There had been an allegation that pain medications had been stolen from his car when CCTV footage showed that that had not been the case. So there was some abuse of those pain medications. And
I know that he moved to cannabis and methadone, but the cannabis isn't compensable for reimbursement under Workers' Compensation Act this time. So whether or not there was abuse, misuse, or just extended heightened use, could have been all of those. One doctor determined that maybe perhaps there was, and there's an indication of a misuse from use, but we don't really know at that point. Would you agree there's nothing in the records that cites a declaration of misuse or abuse of the oxycodone or OxyContin?
I know that there are some records in the United Pain Clinics in the nurses' notes that talk about there being indications in the hospitalizations not to provide him with narcotic pain medications and violations of those contracts.
Okay.
And I, again, believe that that's in the individual notes for some telephone conferences as well.
So your contention is the contract violation would rise to a level of misuse or abuse?
Yes. And I would also assert too that even when on the narcotic pain medications and at the time of the settlement, he was not pain-free. Again, the deposition transcript that was provided as an exhibit documents that he was asked by his counsel if he was on any medications and what happens when he's not. He said his pain level was 4 out of 10 when he was on the narcotic pain medications, but without it, it goes up to a 10 out of 10. That's extreme pain still, and unfortunately, you know, circumstances may change, but this extreme pain and his inability to work has continued since since the stipulation for settlement was filed. So that's another one of the factors here is there's just been no documentation of his change in the ability to work, and that he has not worked since the stipulation happened. This was well before the unfortunate surgery in January of 2022. There's 7 years showing an inability to work there.
Let me ask you a question. In the stipulation for settlement that's asking to be vacated, again, there were some medical reports that were done, and I understand this is under the different kind of system, but there was a employer and insurer, at least as part of the process, a vocational report was done by Jan Lowe. We don't have any information. What can you tell me? What did she say about Mr. Melius' ability to work back at the time of the stipulation following her evaluation?
And Your Honors, I apologize. I am also stepping into this file and was focused on the materials that were submitted to the court. I do not recall. That was not submitted with the petitioner's brief, so I would anticipate it if it had favorably reviewed that and showed an ongoing ability to work, then that probably would have been attached as an exhibit.
And I want to follow up on a question that I asked Mr. Batchelor, actually the same one. There's the $175,000. As you mentioned, there was the indemnity benefits paid prior to that. What about the third-party settlement money? Should we consider that in considering the degree and or the proportionality of the settlement to the degree of disability?
I think when you're looking at a fairness argument, that is a policy argument, you can look at the employee as a whole and how he was compensated for that injury. And this shows additional compensation, show that overall there was fair compensation for it.
We would then probably consider only what he netted after the reimbursement to your client from the third party. He didn't get the whole third party settlement. I mean, the 061 recovery to your client, subrogation.
And I was trying to go through the WCRA. When I look at those payments, I apologize. I didn't see that in the NAG settlement. I did not see a mention
Well,
of.
if it was a NAG settlement, that's different. So
Yes, I believe it's a NAG settlement.
Okay.
And I believe at the top it says NAG release.
All right. I don't know if we even have that documentation.
It is attached to our brief.
Okay, I may have missed it.
Yep.
I apologize.
That's all right. I can, it's one of the later exhibits that's attached to respondent's brief.
Let me ask you this question, because Exhibit 2, which is the WCCA interim loss report, they have a total to date as indemnity, medical, and then in paren, there's a recovery of $112,697.86, which would appear to me to be something that was recovered by the employer, insurer, somebody from the third party recovery, because it usually goes 1/3, 1/3, 1/3. 112,000 is about a third of 277,000. So do you know whether or not where and self-insured made a recovery from the third party recovery or not?
I do not have that information off the top of my head. I believe maybe possibly that Mr. Melius would know how much he netted from that. So attorney might have further information.
Counselor, the assertion in your response is that the employee has been accurately and adequately compensated. And I know I make that distinction, and I'm going to assume that you do as well, that he's been compensated the degree of disability he has experienced. And I think that's on page 12. So I take those two and I look at them, and even if I add in the numbers that you are asking us to, if he was PT at the time of this settlement, what's your discount rate here today? After I offset dollar for dollar, it was paid up $175,000. Does that put me into what, 2.5 years? I mean, when you calculate that benefit package and you're discounting it to present day value, and then you take another discount, that discount's pretty steep if he is PT, the date of settlement, and he's still today seeking benefits if he hadn't entered into the settlement. And then, of course, you move into a life expectancy chart. Is it really adequate? 175,000. That's your point blank.
Your Honor, I believe it is, and I believe that they contemplated it at the time. This was a negotiated settlement where he was represented by counsel, and
I'm asking your opinion. 175,000 if he is PT retroactive to the date and there hadn't been a settlement, your payout really moves to more of a 900,000, maybe even $1 million of the total value if paid out in the length of the case.
Yeah, and that has to take into consideration the prior payments that were made as well.
Then it moves me to 303.5.
Yeah.
And even in that sense, and even if I don't put into the third party action, the additional sums, they're really adequate?
I believe so, given the fact that he continued not working in the 7 years that went up until the surgery in January of 2022, and he's remained unemployed at this time.
But if he had received a PT benefit, and even within the calculations of a vacation, a stiff that might happen, and the life expectancy is 175,000. If I started today and move it into a life expectancy chart, what is the discount? 175,000 if offset.
I do not know.
When you go and you look at, you tell me that it's an adequate settlement back then, it is a large sum. Is it because that most settlements move into a steep level of discount that perhaps they shouldn't, or that's just the policy and practice of the workers' compensation laws and settlement of cases? 175,000 is a lot of money, but it's relative to the present day value and what the employee might have available within their lifetime if that person is permanently totally disabled. So I'm not so sure that 175,000 is adequate. Tell me why I might be incorrect in that assumption.
Again, Your Honor, I don't know that we would be having this conversation if the employee didn't have this unfortunate outcome. He remained unemployed, and would we be here again doing that? The employment status has not changed since then. And that is a big point. Workers' compensation, unfortunately, does not compensate for that pain and suffering that might happen. And it is unfortunate, but the permanent total disability was anticipated at the time. It went into both sides' settlement evaluations, and we reached a negotiated agreement. And again, I believe it is further demonstrated just by the fact that there's not really been any ongoing employment even prior to the negative surgery.
So your argument is even in the third party system, the fact that it could have been pain and suffering, which isn't compensable, should be added to the total value, or it should be discounted from it? I mean,
I think these are applying to different sections of it, and so that's, I guess, going to the fairness argument of it when you're looking at the fairness of it. So I believe that that should be added if we're looking at the overall exposure and if he was fairly compensated for it. Your Honors, I would like to also point out that as part of the requirements here is that there'd be a change in permanent partial disability. In this case, there has not been any opinion providing or medical opinion providing that rated change in permanency. Mr. Melius, he did undergo a DRE with Dr. Larkins, where both sides in the DRE are allowed to submit questions and interrogatories to him. No interrogatory was posed by a petitioner about if there was any increased permanency at that time. So there's no, at this time, it's our position that it is premature to assess a permanency.
that may be, but can we reasonably anticipate a minimal? And the statute alludes to that as well. And isn't the insurer required to pay the minimal ascertainable amount of any permanency prior to a rating?
And well, my understanding is he's not at MMI at this point. We don't know. So at this point, without being at MMI, it's premature to assess.
Is there any, I didn't see any, is there any evidence that suggests that his essential paraplegia is going to improve?
It's my understanding that he's still seeking medical treatment and working with his providers on that, and that's from the separate case, and so still trying to improve there. That's my understanding of it.
Okay, I mean, I'm sure that there's always efforts to try to improve it. I mean, is there any realistic, I mean, the point being, I mean, your argument is, well, there's no evidence that he has a higher permanency rating because there is no rating given yet. But seriously, can't we just say it's gonna be there? It's gonna be pretty high.
And again, if that was going to be the case, I don't know why that evidence hasn't been submitted by opposing counsel.
Well, apparently because no doctors are willing to rate him yet, but I mean, I get what you're saying. And I assume you get what I'm saying.
Yes.
Yeah. Let's leave it at that.
Absolutely. Again, I would like to just go back to the fact that all of the factors, the fondness factors need to be met in order for a stipulation for settlement to be vacated. But even if there are some questionable ones, one of those factors is the ability to work and a change in the ability to work. And the affidavit that was provided by counsel, again, does not provide any documentation of any sort of job search. And there's the fact that disability benefits were denied, presumably based on him applying based at a more recent date of disability. The fact that he did not meet the requirements, the threshold to have disability benefits, shows that he was not working at that time. He had stopped working after the surgery or after the stipulation for settlement was entered. So really there has not been a change in that ability to work. And with that, any further questions? Okay, well,
Hey, Judge Miller, question?
No. Thank you.
all right. I think I'm right on time then. So thank you, Your Honors.
Thank you very much. The matter will be taken under advisement and decision will be issued in 90 days. Thank you both very much.
Thank you so much.
Thank you.
Good to see you too. We can really sympathize with taking over.
That's good, just like let you know that. Social Security has.
Oh,